One of the most difficult concepts to define is the unauthorized practice of law, or UPL. In general, this refers to someone who is not a lawyer performing acts only lawyers can do. As we'll discuss, there are some exceptions to this concept. UPL is a difficult concept because there is no universal definition and usually no guidelines. There are some activities that are generally accepted as the unauthorized practice of law. Representing a client in court is nearly always an attorney activity, except a few jurisdictions allow for a non-attorney to represent a client in certain circumstances. Giving legal advice to a client and negotiating a settlement on behalf of a client are activities strictly to be performed by an attorney. Although paralegals can draft general pleadings, any pleadings that require specific legal knowledge should be drafted by a licensed attorney. All pleadings should be reviewed and signed by the supervising attorney as well. Disbarred or suspended attorneys who act as though they have a valid license are also conducting the unauthorized practice of law. Finally, if a paralegal acts outside the scope of the authority designated by their supervising attorney, they are also likely committing UPL. UPL is a concept that has been established by case law, codes of professional conduct, and has been codified in state statutes. The unauthorized practice of law is a misdemeanor violation in most states and can be punishable by fines or even jail. The most prominent code of conduct in the legal profession is the American Bar Association Model Rules of Professional Conduct. Although these guidelines have not been adopted in most states, they are considered the standard in the industry. These guidelines set forth basic rules that help to prevent UPL. The ABA requires that attorneys must supervise all paralegal activities because they are responsible for all activities performed by their paralegal employees. Attorneys are also not allowed to assist others in performing the unauthorized practice of law. This can include assisting paralegals and disbarred or suspended attorneys in filing cases. The ABA model rules for paralegals are quite similar. Paralegals cannot establish the attorney-client relationship, meaning that they are not able to accept a client's case. They also cannot establish a fee agreement for legal services, although paralegals are able to discuss an agreement once it has been signed by both the attorney and client. Any specific questions, however, should be referred to the attorney. Finally, paralegals cannot give legal opinions or advice to clients, even if they know the subject area. Each case depends on the facts and should be analyzed only by a licensed attorney. The model disciplinary rules of the National Federation of Paralegal Associations, NFPA, are much more vague. Like most of the other ethical codes of conduct, the unauthorized practice of law is not defined. Unlike other codes, the NFPA does not specify the prohibited types of conduct. Instead, it states that paralegals should maintain a high standard of professional conduct. The National Association of Legal Assistants, NALA, mirrors the codes of both the ABA and NFPA. However, it also indicates that a paralegal is required to disclose his or her status as a paralegal in all situations. Other acts that may be prohibited include conducting depositions, performing alternative dispute resolution, or ADR, executing a will, selling legal documents, attending real estate closings, and signing pleadings. While it seems that there are many restrictions for paralegals, there are many legal activities that can be performed without fear of UPL allegations. Paralegals may draft pleadings except as specified earlier, conduct client and witness interviews, prepare discovery, conduct legal research, draft letters, and draft other legal documents. There are certain circumstances where paralegals are allowed to represent clients in court. Over 25 agencies allow non-attorneys to act as counsel, but each has different requirements. Some require that a paralegal have specific education or experience, while others require an exam. UPL may also be a concern where a paralegal contracts to perform independent legal services such as document preparation or drafting. The key to avoiding UPL in these situations is to make sure that the paralegal continues to be supervised by a licensed attorney. It may be difficult at times to avoid UPL, especially around friends and family, but there are some tips that may help. Avoid answering any legal questions for your friends and family, even if you may know the answer. Do not provide an estimate as to the cost of a legal service. If someone asks a question about a specific set of facts and wants a specific answer, refer them to an attorney. Do not answer the question yourself. As a paralegal, you should always work under the supervision of a licensed attorney, even if you are performing contractor services. Also, it helps to know the particular rules regarding UPL in your jurisdiction.